We close the chapter with one of the most fiercely contested liberties in American life, the Second Amendment. Its text reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed." And notice how much hinges on how you read that opening clause about the militia. Here's a fact that surprises many students. For most of American history, the amendment was understood primarily as a protection for state militias, and the Supreme Court issued essentially no major Second Amendment ruling for over 2 centuries. The modern individual rights interpretation is actually quite recent. The turning point was District of Columbia v. Heller in 2008. In a 5-4 decision, the court held for the first time that the Second Amendment protects an individual right to keep and bear arms, unconnected to militia service, including the right to keep a handgun in the home for self-defense. 2 years later, McDonald v.
City of Chicago incorporated that individual right against the states, so it binds state and local governments too. Then the doctrine expanded dramatically in New York State Rifle and Pistol Association v. Bruen in 2022. Writing for a 6-3 majority, Justice Thomas held that the right extends to carrying a firearm outside the home for self-defense, and crucially, he announced a brand new test. Under Bruen, a gun regulation is constitutional only if it's consistent with the nation's historical tradition of firearm regulation from the founding era. This historical tradition test replaced the older means-ends balancing that lower courts had used, and it made it substantially harder for governments to defend gun laws that lack clear analogs from the late 1700s or early 1800s. The practical fallout has been sweeping. Federal courts applying the historical tradition test have struck down a range of firearms regulations. But the court did provide some clarification in United States v. Rahimi in 2024, upholding the federal law that disarms people under domestic violence restraining orders. The key move there, the court said Bruen does not require an exact historical twin, only a law that's relevantly similar to historical regulations. Still, as of 2026, the full scope of permissible gun regulation under the Bruen framework remains deeply uncertain. Dozens of federal court decisions applying the historical tradition test are still working their way up toward the Supreme Court. So this is a genuinely live, evolving area of constitutional law, and a fitting note to end on because it captures the chapter's central theme. Civil liberties are never simply settled. They're continually being defined, contested, and redefined through the political and judicial process.